the application in either of the provisions.
But when you are stating you are going under 163, you will go on. The court will go under 163 only now.
Sir,
Whatever the nomenclature,
we have no say when the judgment.
But you have argued this, no? It is there because you argued this.
No, this is the observation of the court. It is not my
argument. Observation of the court will only come from the argument made by the counsel.
Right? Sir? I cannot comment on the order, but if YouTube is
commenting, it was argued by you. That is what I am saying.
Since if YouTube is checked, my argument, I have not stated that my application is in some other provision.
Because here the Honorable High Court has told me to decide this way. Whether it is under section 163A or whether it is under section 1.
It was under 163 only. I mean, since earlier round of litigation, where the earlier Honorable High Court has remanded the case, there also it was under 163A because it was remanded to go into the aspect of Sinitha judgment.
Or negligence part.
Self-negligence. Now it is overruled in Sunil Kumar saying that the court cannot go into the negligence in 163 application. So therefore, it was remanded, my submission is, it was remanded for the limited purpose to ascertain the aspect.
Now, in the view of the above order, the award is causing set aside and the matter is remanded back to decide the aforesaid claim. Since this is the second round of litigation, the question is reached before the MSCP this.
MSCP made Rajkot in exercise of jurisdiction under section 21. So it was specifically remanded to the district judge, honorable district judge.
Because I don't have like 2 rounds of litigations are over. In the first round, negligence was.
Yes, sir.
Negligence was not considered in the first round of litigation.
G.
And then it was again remanded. Then negligence was again that preliminary issue was raised, and on that ground it was struck down. So now what I have to decide?
Now, very important. Yeah, that is the honorable court's query is very important. Now, kindly see the earlier order. That will throw the light. That is first appeal 2356 of 2009. Dated 1st March 2012. But now the insurance company is coming forward with other 2 arguments, saying that the driver, my client, was not possessing.
Because it is remanded, I have to do it all afresh.
But that I will satisfy. Once it is remanded for specific purpose, it is not open for the parties to argue on other aspects of the matter, or it is not open for the court to go into other aspects.
I am told to go afresh. Nothing new. All those orders are all set aside.
G. No, therefore I will try to satisfy the honorable court that it is not open for the parties or court to go into the other aspects of the matter when it was earlier. Earlier it was remanded for specific purpose to ascertain the aspects which has been held in Sinitha. Kindly see that order. That will throw some light. The honorable court is having that order.
Yes, I have. 1/3/2012.
1st March, yes, 1/3/12.
Okay.
Yes. Then first paragraph, so and so. Then second paragraph, this is relevant. It has been mainly contended on behalf of the appellant insurance company that those specific contention regarding liability, negligence, other submissions were raised before the tribunal. The same were not appreciated in its proper perspective. Reliance has been placed on the decision of the apex court in a case of National Insurance Company versus Sinitha and others, 2012 to SSC 356, and it has been prayed that matter be remanded to the tribunal concerned. Now, only one judgment was placed into the service, that is Sinitha, saying that he was negligent and that issue has to be gone into. That was the only submission which was raised, and only judgment was placed into service before the Honorable High Court. That is Sinitha.
Right.
Now paragraph 3. Considering the facts of the case and in view of the principle rendered in Sinita's case, supra, it would be appropriate that tribunal reconsiders the matter. Consequently, the impugned judgment and award is quashed and set aside, and the matter is remanded to the tribunal concerned for consideration afresh in light of the decision rendered in Sinita's case supra. Both the sides shall be at liberty to adduce evidence which shall be duly considered by the tribunal in view of the decision referred to here in above. In view of the decision referred here in above, that is Sinita only. No other decision was pressed into service. Even the court has not observed that any other decision be considered or any other law point be considered. Until the claim petition is decided, the tribunal consults and investigates and so in the appearance shall be permitted to be accumulated. The entire amount with it shall be disbursed in favor of the party who finally succeeds in the claim after giving necessary so and so. Now, that this is very important. When the earlier round of litigation, it was remanded for specific purpose. Now, indirectly, they cannot open the Pandora's box and contain other 2-3 law points, which has been attended finally.
I'm not in that part. That part of litigation was over when the learned trial, my brother judge passed an order, right?
Yeah.
So everything was done, went again. Now read para 6 of the new judgment.
Now, that is important. In the before that, kindly see the judgment of the predecessor court. When it was earlier remanded, it was decided by this court, tribunal, Rajkot. The tribunal, kindly see, had that is also
Para
very
3. Para 3.
Paragraph?
Paragraph 3 of the Honorable High Court.
G.
The recent one. In my view, in order to become eligible for compensation of loss. In this
Paragraph 3 of the earlier remand?
No, the second remand order. 11/24.
G, sir. From the record, that paragraph 3?
No, I'm reading the Honorable High Court's order.
G, sir.
Para number 3, the later one. 11/10/24.
Sir, sir.
The contentions, what my brother judge said while rejecting the application is in para 11, I think.
G, that is very important. May I read that?
Yeah, read.
What the court has said, earlier court,
right.
The claims tribunal Rajkot had gone into the other aspect that he steps into the shoe of honor and therefore he is not entitled under 163A. Now that judgment, they rely on Nigamma's judgment related to stepping into the shoe. Now dates are very important. Kindly see the first remand order is dated 1st March 12. The Nigamma's decision came, that is kindly, I'm sorry sir, I may request the Honorable Court to note down the dates. Nigamma's judgment came on 13th May 2009. That is before earlier round of remand before the High Court. And the citation of Nigamma judgment is 2009 13 SCC 710.
2009?
13 SCC 710. Which has been decided on 13th May 2009.
Right.
So therefore, when earlier round of litigation, when the High Court remanded the matter in the year 2012, in March 2012, their judgment was very much available with them, with the insurance company. They have not pressed into the service this decision when earlier the case was remanded by the High Court.
So what is the law? What is the law when the court says, look afresh?
G.
What is the law on that? How much the court can go into?
Afresh on the context of what has been stated in the earlier paragraphs.
Right.
In the earlier round of litigation, the
Now,
court
do
has
you have
said,
some case law on that?
yes, case law, I'm keeping two judgments with me.
That
But not,
if
not
the
about the,
court says afresh means only to whatever stated in those lines.
yes, my submission is that only. But
Because paragraph number 6, if you read paragraph number 6 of the second judgment, second remand order.
second, yes, similarly, earlier also the court has said afresh.
No, earlier it was said in the lines of Sunita.
અને સાહેબ
And this
એમાં પણ afresh શબ્દ વાપરેલો, word is used.
Afresh in the lines of Sunita only.
Sunita only.
Barabar?
Ji,
Now,
sir.
this second remand order, is there anything that way?
Sir, this, yes, I may precisely point out. The Honorable Court is right, it is said that afresh. My submission is, first remand order will not dilute because the insurance company has not challenged first remand order.
Has not?
Insurance company has not challenged first remand order before the Supreme Court. Right?
No, it is on the insurance company who went there, no?
Yes, yeah, they went there.
But,
They have obtained this order, remand order.
right.
They were not
You have challenged it.
No, we have also not challenged because it was for limited purpose.
Right. Then that limited purpose was defined it and decided this way or that way. It was whatever it was.
So that attained finality.
Then again, it was finally decided by a tribunal.
Decided.
Challenged in the High Court.
We challenged it, yes.
Right?
Yes.
You got one more order in which it is said you decide all afresh.
But that, in my submission, that is not the...
Just read para 6.
Because the court has...
Para 6.
The coordinate bench cannot overturn the earlier order.
Which one?
The coordinate bench subsequent remand has not touched the earlier order. Saying that now you open the Pandora's... So now you open the Pandora's box in my appeal. Sir, how it is possible? They want to open Pandora's box in my appeal.
But then that is what you should have told. Only this issues
So
could have been defined.
Therefore, I have...
There are no issues. No issues have been framed. By the...
Kindly see again, sir. Kindly see paragraph 3 again. The court was in paragraph 2 and paragraph 3 dealing with Sunita's case only in the subsequent order also.
No, that is, they are saying it is about second litigation. There are the facts, Chayato. From the record.
Paragraph 3.
Para number 2 is the facts.
Ji, sir. And kindly see now paragraph 3.
Para number 3 from the record, again fact.
Yes, from the record. Right.
Now, para number 6 is what?
So the court was dealing with Sunita only. That was my submission.
No.
The court has observed.
No.
From the record.
Para number 2 and 3 are facts. From the record. Nothing
yes, facts. It's not difficulty. But
okay, there is no ruling by the court. Now, para number 4, 5, and 6 are the actual paragraphs. Heard the learned advocates for the respective parties.
Ji.
And number 5 read is regarding.
I agree with the Honorable.
And number 6 is the operative part.
I agree with the Honorable. Now,
the operative part is saying is quashed and set aside and remand back and to decide afresh.
Yes, sir.
Everything.
No, everything. With great respect, I may submit that insurance company's advocate has not relied in the second remand as well. Any other decision except Sunita?
You understand? Where do you get that from me?
The court has said that if you refer paragraph...
See, in this paragraph number 6, what has the Honorable Court said?
Sir, I agree. It is afresh.
So now where do you come?
But in light of Sunita?
No, where is it?
Yes.
Where is it?
But light in Sunita will not dilute.
See, that has
because earlier remand order...
That already has been followed.
So, sir,
it is over now.
Sir, what I submitted, in my opinion, how the leverage can be granted to the insurance company to argue.
The court said, because the Honorable High Court said
court will never say that because it was my appeal.
See, read it, para 6.
Ji, sir. In view of above. That is in view of above. Kindly see. In view of
In
above.
view of what?
In view of all above paragraphs.
No, facts is not would not be a matter. In view, if there is a discussion in view of above, those are facts. Para number 2 and 3 is a fact.
Three are the observations. Paragraph number 3 is the observation.
Paragraph number 3 is not the observation.
Paragraph number 3 is not facts.
No, paragraph number 3 is a fact. Look at it.
Kindly see.
From the read paragraph number 3. Please
Paragraph
read it.
number 3.
Please read.
From the record.
Yes, from the record.
Yes, sir. I am
It
pointing
is a
out that.
fact. It is a fact. Paragraph number 2 and 3 is a fact.
Yes. Record
Now
indicated.
use the facts. That
Facts is.
already happened.
So I am on facts only.
Hmm.
Facts is that earlier it was remanded. The fact is earlier it was remanded in
Yes,
Sinita.
right.
So that is the facts which has been dealt with by the court.
And it has been also dealt in para 3 that the tribunal has passed this order, para 11.
The preliminary issue. Yes.
Right?
Yes. Now kindly see.
Now come to
I may try to other.
There is no discussion whether it was wrong, it was right.
No, it is preliminary issue. Court has said that it is wrong.
Where is that?
Kindly see. Paragraph 5.
Right.
Since the litigation under MB Act is not adversarial litigation, the tribunal is not required to decide the issue as a preliminary issue on law point.
Right.
So tribunal.
Now I don't have to decide a preliminary. I have to decide the whole case in afresh.
In light of Sinita, that three words.
That is not. That is
three
not.
words.
That is not there in the order. That is why I am saying. Where is it?
But earlier order is not.
And on the contrary, you have argued that, sir, the court has not yet decided under 163 or 140 or 166.
No, sir,
Court has not yet come to a conclusion under what section.
Sir, those 3 lines are general observations.
No, that they came from.
It is the statutory liability of the tribunal to decide under any of the provisions.
No, but then that was your submission before the court, no?
ના સાહેબ મારો એવું સબમિશન હતું જ નહીં. It is not recorded in my submission.
No. Those observations would come only in light of your submission.
No, sir, I can come with the YouTube arguments. If I have not made any such.
that I have to read the order only. What comes to me is the order.
So, sir, my submission is these 3 lines are general observation. And by way of subsequent remand order, the earlier order will not get diluted. Because earlier it was specific.
Now again, okay, let it be. It appears
and another point in my favor is because now they want to open other aspects of the matter in my appeal because I have preferred appeal against the order. They have not gone to Supreme Court. There, section 1052 of CPC is very clear. May I read that 105 subsection 2? There are judgments on the line, but section itself is very clear. CPC section 105 subsection 2. May I read, sir?
May I read it? Please.
That relates to other orders, and subsection 2 is notwithstanding anything contained in subsection 1, where any party aggrieved by an order of remand from which an appeal lies does not appeal therefrom, he shall thereafter be precluded from disputing its correctness.
Again,
so they have.
Again, please read again. Whoever. No,
section
105 CPC.
Of CPC. Subsection 2 I rely.
Yes.
So indirectly, they want to challenge the correctness of the earlier order of remand, which is not permissible unless they approach the Supreme Court.
But they are not saying that.
Therefore, they have not challenged it. Therefore,
They have complied with both the orders. They are agreeable to both the orders. There is no
then
challenge.
it is not open for them to argue on this other two decisions of steps into the suit and driving license. I will satisfy the Honorable Court on those two aspects as well. They cannot argue other points, and it is not open for the court to decide other points when earlier remand order is not assailed before the Supreme Court.
Yes.
That is the first submission. And I will point out the decision on section 105, subsection 2.
105, I'm clear. Don't worry. You don't. I have not allowed them also, no?
Yes.
They have accepted the fact.
They have accepted.
Yeah.
Now, on the aspect of stepping into the shoe, there are two hurdles which I have to cross. One hurdle is stepping into the shoe of owner, saying that he was driving the vehicle. Now, kindly see the policy and terms which.
Let me be one clear that you are going under 163.
163A, capital A, yes.
Right? Then negligence I don't have to look into.
Ji, sir.
Well, I have to only go for liability.
Yes, absolutely right.
Right? So now only on that much part we need to go, no?
So earlier this tribunal has held that because he was driving the vehicle, he stepped into the shoe of owner, and therefore I am not entitled.
Right.
So my first contention, then I am coming on merits. Other two contentions. Now, other two contentions are that stepping into the shoe, what has they have raised in the written argument. And having of second one is not driving license. Now, they have submitted terms and conditions of the policy in the present matter.
Right.
Kindly see that terms itself. The terms permit the driver to take the vehicle with the permission of the owner. Kindly see that terms. Page number.
Page number?
Page number 3. That is section 2, liability to third parties.
Of the policy?
રોહિતભાઈ સાહેબ ને આપે મને મોકલાવે ને ટર્મ્સ આપો જે which has been produced by the insurance company.
Yes.
But there in terms, first page is schedule of premium. But one other, if all other arguments are not believed, kindly see the 50 rupees is paid for personal expense.
Policy is what?
It is package policy.
Right. Third party, you paid a premium of 160 rupees. And you paid for PA cover for owner driver to a limited liability to of 1 lakh rupees, right?
Ji.
Of 50 rupees.
Ji, sir.
Even if the driver would allow you, if the owner would allow you to drive the motorcycle, your limited liability is 1 lakh rupees.
PA cover to owner driver.
Yes. Our limit liability of rupees?
Yes, if all other arguments are not believed.
No, I believe all your arguments. Taking into consideration that you have stepped into and you have the permission to take the motorcycle.
Then liability, the Honorable Court is saying 1 lakh rupees, right?
It is written in the PA cover of 1 lakh rupees only. Have you paid anything other than that?
1 minute, I may point out. Now kindly see the terms, page number 3. That is paid. There is no other separate premium.
Page number
3. There, section 2, liability to third parties, where item number 3, in terms of and subject to the limitations of the indemnity granted by this section to the insured.
Indemnify any driver who is driving the vehicle of the insured's order or with the insured's permission, provided that such driver shall, as though the insured observe full and subject terms and conditions. I am not saying no to that.
Yes, so there is no limit.
Yes, I am saying yes, but only to 1 lakh.
No, there is no such limit prescribed here.
Driver, when the owner itself is prescribed, then you cannot go beyond the owner. When the owner himself
that
is to a
person.
limit of 1 lakh, can a driver go to 10 lakhs?
Yes, that hurdle is there against me.
So,
yes.
At the maximum, you say, okay, you had no driving license, so you were into the shoes. Everything I believe you. I say that you were authorized to drive the motorcycle.
G.
What is the limited liability?
Yes, that I am saying if other.
Can I give more than 1 lakh?
Yes, it cannot be. It cannot be. But now, therefore, first hurdle and second hurdle is driving license.
Driving license, chalo, I don't even believe you had a driving license. I take it.
So
then
now,
only 1 lakh.
now I will have to stuck to my point, which is law point, which I am arguing. That it is not open for the parties to go beyond the review order. Going into the other aspects of the matter of Nigamma is not permissible because Nigamma judgment was available when it was remanded in 2012. Nigamma judgment is 2009. They have not pressed into service this point before the Honorable High Court. Nor they have challenged this order before the Supreme Court. Therefore, they are precluded to go indirectly into correctness.
No, so if there is some correct law on record, and if a person doesn't say that and you suppress it, then is it a big
I have not suppressed.
No, I am not saying you suppressed. You knew also about Nigamma's judgment.
So why should, when the court is not going into?
Exactly. So what does it become?
It is the duty. It is the duty of the appellant. I am saying that I am covered because it is a package policy. Why should I go into all niceties of the law? I am saying that I am covered. Insurance company is also believing that I am covered. Kindly see, this is the nicety. Because they have not pressed into service of Nigamma's decision. They have not raised point in the earlier round of litigation. Remember, these are poor persons from small village. We are dealing with third round of litigation.
1 second. Look at the WS of the insurance company.
Yes, sir. It is exhibit 13.
Exhibit 13, maybe. Maybe exhibit by.
It is on the premise that he was self-negligent and driving license.
Driving license was there that time also?
The contention was there.
Exactly. So now can you say that he has brought in a new contention?
No, when you may write anything, but when you are not pressed into service in the final arguments, then it is not open to go back to the pleadings.
License issue is also there?
License is there, but where is the argument in the earlier round of litigation?
We'll see that. Liability to third parties?
And there is no, probably what I understand, there is no contention about the stepping into the shoe. No such contention is there in the written statement.
Yes. Anything else?
So if the Honorable Court permit me, I would rely that P. Saguna's case, which has been decided by the High Court, saying that even if the person is self-negligent, he can claim under 163A, which has been taken to Supreme Court, and the Supreme Court has dismissed the SLP, saying that the law point is kept open. P. Saguna's case, which I have given the copy.
If it has gone to the Honorable Supreme Court, then let it be. What?
It is decided. Supreme Court has dismissed their SLP, saying that, kindly see,
No. Okay.
having gone through, I have given the P. Saguna's case.
P. Saguna.
Ji, sir. Which says, the Gujarat High Court has decided that the person who is borrowing vehicle is covered under 163A. Because there is
I'm not saying no. I'm not saying no. What is the liability limited to?
There is no limited liability as per this decision. As
What?
per this decision, there is
You are barred
limited
by
liability is not there.
You are barred by the contract
No.
between the insurance company.
Because the court has said that there is notwithstanding clause. Kindly see 163A. Notwithstanding clause.
As far as what? Negligence, no?
Not a single line can be looked into. When notwithstanding.
What are you trying to say? That 163A is only regarding negligence, no?
No.
Then,
I am saying that the person who is borrowing vehicle from the owner,
right,
is also entitled to unlimited liability. Unlimited liability.
To what? The liability that has been agreed by the owner.
No.
Not even in the sky then.
Why? Because it starts from notwithstanding anything. Non-obstat clause. Kindly see 163A.
I understand that non-obstat clauses as far as liability of the insurance company is concerned. When you agreed with the insurance company ki 1 lakh સુધી paisa nahi.
I am not owner, sir. I am not owner.
So you are, what is it for? 163 is for whom?
Please, sir.
You are saying that in this judgment, it is said that 163 could also be implemented in the case of a person who borrowed a vehicle.
And court has gone to the extent that even owner can claim. That the court has said.
Exactly. When the owner.
But not limited.
But you limited it by signing an agreement.
Sir, that is extra. Yes, that is extra premium paid. But there over and above. Not the unlimited liability.
Exactly. If you don't pay a premium, you can't get anything then.
Then also I am covered in view of this decision.
Now, where is it? Which paragraph?
Sir, it is very P. Saguna's case. I don't have right now copy. But kindly see the tribunal has discussed while granting me compensation. When I was awarded compensation.
In the first order.
In the first order of tribunal. It has been reproduced. Even driving license arguments are also taken care of. In the first order.
Expression not including anything contained in say on the timing and for use, which goes to show that the parliament accepted the condition with the wide nature, which would mean that the provisions of section 163 would apply despite the contrary provisions against existence in the said act or the law for the time 163 clause where even negligence is on the part of the victim. It is the area of an exception and concept of social justice. The scheme of the provisions and the third party is provides that if an award in respect of any liability is required to be covered by the policy, and the provision exactly, that is what I'm saying.
Please.
That is exactly what this judgment saying, para number 8.
Somehow my copy is missed.
It will depend upon your contract with the insurance company.
Yes. But I missed the copy here. It is not in my file.
It is there in para 8.
But I will elaborate arguments on Saguna judgment, where the court has not limited the compensation. I'm sorry, this copy is missed in my file.
Doesn't matter, doesn't matter. Yes. Anything else?
So that is carried before the Supreme Court. And the Supreme Court has dismissed the SLP. That order I have given, means the copy is available to my counterpart.
Yes.
Now, so far as driving license, the Honorable Court is saying that it is not required. So I may be permitted, or
no? Yeah, as far as driving license is concerned, that argument was taken from the beginning only.
Yes.
That was never an issue. That something new has not come up.
Yes.
It is the court that did not consider it.
So far as the stepping into the shoe of owner, there is nothing in the written statement.
That is okay. I will not take it. I take you as an authorized owner only.
So far as driving license is concerned,
that is taken in the WH also.
Written statement, but the argument was advanced.
No, the tribunal did not take it into consideration.
Tribunal has dealt with both the aspects.
Yeah, what is
self-negligence and driving license, both.
What did the tribunal say?
G.
But that order was quashed and set aside. That's the reason. Problem is that.
It is remanded on the aspect of Sinita only.
Order is
set aside, yes.
So that now I have to again refresh, decide it again only, no?
G, sir. G.
That issue will remain.
So my contention is, so far as other 2 points of stepping into the shoe and driving license, it is not open. When the scope of remand was limited to consider the case in light of Sinita. And those arguments were not advanced in the earlier round of litigation. Nor those arguments are not even advanced in the second round of litigation before the High Court. The High Court, those arguments were not advanced. So the court has focused the case only related to Sinita. No other aspects of the matter were open, even in the High Court. Kindly see. So now my submission is that in view of Sunil Kumar judgment,
Which is when? Sunil Kumar.
Sunil Kumar, that is 2019-12 SCC 398, whereby the judgment of Sinita is overruled. That is end of the matter in my submission. Therefore, my client is entitled, because initially it was remanded on the aspect of self-negligence. Sinita was decided on the premise that the insurance company can lead evidence with regard to negligence of the victim or deceased. Now, this judgment says that it is not open.
Yes.
So this judgment has overruled the judgment in case of Sinita. Therefore, it is end of the matter in my submission, and my client is entitled to compensation. Not
Okay.
limited to any extent, unlimited, which is provided under the statute.
Okay, sure.
Now, the other two decision, in other one decision with regard to driving license.
अपना कॉपी करेंगे नोटेड फॉर्म मैंने बताओ कोड चलो चालू कर दो आपने કેટલું રહ્યું તો તમે બાકી રાખજો કેટલું રહ્યું not more than 15 minutes चलो कर दो so case number કેટલું છે 15 by 15 એક મિનિટ It was lastly argued on today is 22nd of January. No, nothing. હું બધું અલગ અલગ રાખીશ. I don't get the what is date wise nothing. Okay. It is 53 of 15 by 15. 15. Yes. May I please order? Sir, this present appeal is filed mainly on 2 counts. As per the appeal memo, page number 9. You had argued last time that the plaint was yes. Page number 1, last 4 lines. Yes, sir. Plaintiff pure purchase this in 263. Yes, sir. Exhibit 96 and 148 you have referred. Yes. In cross-examination, exhibit 109 you got. Yes, sir. Right? Yes, deposition of defendant number. Yes, sir. And 172. So I'll no just a minute to illustrate the memory where I was last week. Yeah. Sir, if we start from the appeal memo, page number 9, para 8. The deed is closer. There are 2 counts. On 2 counts, the challenge to this appeal to the judgment and decree of the lower court. The first one is regarding, sir. નામતા નીચેની અદાલત દ્વારા મૂળ વાદી અને ગુજરાતના એપેલેન્ટને ચુકાદાના મુદ્દા નંબર 1 અને 2 માં તકરારી ક્વાર્ટર નંબર 263 ના કાયદેસરના સ્વતંત્ર માલિક અને કબૂતર ન માનવાનો અને રિસ્પોન્ડન્ટ એટલે કે ઓરિજિનલ ડિફેન્ડન્ટને ક્વાર્ટર નંબર 263 સંબંધે કોઈ હક નથી તે મુદ્દાઓ નેગેટિવ એટલે કે નકારાત્મક કરારનો હુકમ લોકોને મદદ કરવા જમણત છે. Now, why did the lower court tell them not? See, to whom? To the plaintiff, appellant. See, because self તમે કહો છો assuming that તમે કહો છો એ સાચું છે. Is the ownership as far as he is concerned would be definitely 150 also a legal hire like me. Exactly. Sir, I haven't this court has said no. nothing doing. You won't get a pie. You understand? What has court said? કાઢી નાખો. અંત से મંજૂર કરીને if would have said na that whatever comes in the right of the share, then it would be okay.
Sir, issue number 1 in the lower court was regarding whether the plaintiff proved that he is the sole owner and occupier of disputed so and so.
Right.
Sir, it was very rightly held negative that he is not the owner, and as per the plaint of the plaintiff itself, he says, I'm not in possession. The defendant
Possession
is
is
in
not
possession. That's why, sir, it was about to come in negative, sir. Sir, once again, I'll give the issue number 1. Whether plaintiff proves that he is the sole owner and occupier of disputed quarter number 263. Now, sir, if we read
Only on sole ownership the court has said no.
no, because it's as per para 1 of the plaint itself, what is conveyed very clearly. Okay, so this is regarding plot 36 and 44. Then it said 44 no plot વેચીને એમાંથી 263 ખરીદેલો means the consideration was of the plaintiff. That's what they mean. અમે વાદીએ ખરીદેલ પ્લોટ વેચીને ફેબ્રુઆરી માર્ચ 73 ના અસરમાં મોય આ પિતાશ્રી નામે ખરીદ સર્વે ક્વાર્ટર ખરીદ કરેલ છે. તે રીતે સર્વે ક્વાર્ટર અમે વાદીની માલિકીનું છે in para 1. And subsequently, sir, what they had gone to કે પ્રતિવાદીની હક નથી આમાં. આગળ I'm sorry, sir, regarding possession, sir.
Possession we know that it is with you.
Means, sir, in the plaint
He has
itself,
admitted that
Yes.
you had taken away.
that the defendant is in possession. So they haven't claimed કે મને પણ હક છે. So obviously, if he would have, I was in no position to say no. જે હું આપું છું, હવે આવી જાઓ, તમે આપી શકશો. But there was no relief or no even a contention in the suit that I'm being restrained to use it to have possession like defendant. His son, I'm son. So there was no like a condition of the plaintiff itself. Therefore, sir, the appeal memo is number 9 para 8. The first condition that the negative thaya છે, and the second issue, it was regarding whether whether plaintiff proves that defendant has no right over the said so and so. Sir, the court believes I'm also legal head of this is father.
That is not discussed.
But sir, once when the plaintiff himself admits that like he's the son, I'm also son.
No. Defendant નું જો શું કીધું છે? Whether
the plaintiff proves that defendant has no right over the said quarter number 263 and the rest. What plaintiff claims in the suit, મને હક નથી આમાં. મારી માલિકી છે તો. So sir,
that is okay.
so the court was right in holding this, that you can't restrain the defendant from using or having possession.
Then what is the third issue?
Then sir, 2A is regarding whether the plaintiff
That
proves
is okay. ये तो जरूर.
I knew. Then sir, the third issue was whether the defendant proves that quarter on defendant, whether defendant proves that quarter number 263 is ancestral property for the party that continued. Yes, about to be. That was had in affirmative, sir. And that's just a common issue. So, sir, the appellant here is regarding the issue here negative appeal છે 1 and 2. The હુકમ નો રદ કરવા અલગ છે. And the second issue regarding as the discussed earlier, sir, was the contempt, but there is no contempt, sir. And that my letter friend also agreed to. Now, sir, I will take the court to the judgments relied by my letter friend.
એમને કયા જજમેન્ટ આપે જ નથી.
No, sir. Because of the burden lies on the plaintiff, sir.
He has not given any judgment as such.
No, sir. On the 22nd January, sir, he has
લખ્યા નથી કોઈ. કેમ નથી આપે જજમેન્ટ?
you know, 5 judgments were written. So લિસ્ટથી આપ્યા છે એમને 5 અને 1 કલમથી આપ્યું છે. Total we relied upon 6 judgments.
Judgment નથી.
નીચે લગાવો. ના અહીંયા 22 તારીખે.
કઈ નથી. જો કામ જો. આગળ તો બીજું છે. આ કામ કર્યું છે. જ છે.
35. I don't know. 22nd January નું છે.
22 છે. હા મિસ્ટર ઉદાણી.
Yes sir.
શેના ઉપરના છે પણ
Sir, 1 and 2 regarding benign transaction and 3, 4, 5 are regarding the contempt.
1 and 2 regarding
Yes sir. Benign transaction prohibition.
right?
Benign transaction.
Benami.
Yes sir. And 3, 4, 5 are regarding the contempt. And one more judgment, sir, he hasn't referred over here, here, but he relied upon the judgment of Supreme Court in the case of Rajkot Reddy versus Padmini Chandrasekharan.
It's an person.
So that is regarding that when the act was
It is not even applicable.
not applicable, sir. That is regarding retrospective or prospective, whatever.
આપણે એને ખબર છે આપણને.
And sir, lastly, sir, it was held in that judgment.
That is something should be continued.
Yes, sir. So I will get only 3, 4 lines. Accordingly, the question for considering is answered in the negative. The registry will now place all these matters before an appropriate division bench for disposing them upon merit in the light of the answer question. Means it was only regarding that whether the effect is required to be given or not given. Means when the 5988 Act was enforced. So transaction prior to or suits prior to filed, whether that will be given effect or not effect, given effect. But sir, that will not come into play over here, sir. And it is of no use over here, sir, to decide the dispute between the parties, sir. After one judgment he has relied upon is of Marcel Martins versus M. Printer. Now, sir, this is in the line of fiduciary relationship. Means trust. Means if I take consideration for B, means B is responsibility. Whenever I will say him to do act like this. Okay, sir. Now, sir, you must have a copy of the judgment, sir. Where is the material thing which comes? So page number 2 of the judgment, sir. And it starts from the last paragraph. In due course, the corporation raised the demand of so and so rupees, sir.
એક મિનિટ પેજ માં છે પેજ નંબર
The page, second page, sir, page number 2.
due course.
You can start from here, sir. Sum of 48,636 towards consider so and so, so and so. Then, sir, the material or the important parallel comes portion comes at the 4th line, sir. Transfer the sum of so and so to an account jointly held by this one number 1 can have this one for purchasing a bank draft in order so and so. So what I mean to say, sir, in this particular case, sir, the transaction or the consideration was from the bank account. Means check was given, draft was given, so the bank was in picture, sir. But in our case, sir, as per the say of the plaintiff appellant, he withdrawn the money and paid the consideration. So, sir, there is a loophole or lapses and lacunas between the consideration which the plaintiff says he withdrawn and paid for the 263 or 44 earlier in the name of father, sir. Sir, moreover, sir, now the page number 3, sir, of the judgment, sir. Second paragraph from bottom, sir. The deposition of bank manager was recorded, sir.
Yes.
Sir, at page number 3, sir, second paragraph from bottom, sir,
Chanu?
judgment. I'm referring this, the judgment of M. Martin, yeah, Marcel Martinez versus M. Winters. So I'm just trying to show that in that,
Which paragraph?
sir, page number 3, second paragraph from bottom, sir. Last 3 lines, sir. The High Court held that the deposition of the bank manager has clearly established. So what I'm trying to convince the court that one of the witnesses was bank manager, and sir, from both the sides, witnesses were examined. But here in captioned case, sir, except for the plaintiff regarding the consideration and the amount, not a single witness has been examined to corroborate the say of the plaintiff, sir.
Thank you, Mr. Bank Manager.
So it starts from the para, the High Court on a reappraisal of the evidence took. In this para, sir, I'm giving. Page number,
Para number?
para number not given, but second paragraph from bottom.
Page number 2.
Page number 3, sir.
Page number 3 માં 2 અને 3 paragraph છે. The High Court further held that.
No, sir. This is in new numbers. The High Court on the reappraisal.
The High Court on reappraisal of
Notice took the view that the appellant had not
succeeded proving the entire amount of
the High Court
consideration
held
for
that
the
the deposition of the bank manager had clearly.
High Court held that the deposition of the bank manager was
So
clearly
that is
established that
material
the joint
for the-
account
for the
held by
fact-
the appellant and his wife had never been operated by the appellant.
Sir, that is only for the fact that bank witness was examined in that case, but here in our case, sir, except for the plaintiff, and that was not the plaintiff, original, the son of the deceased, his legal hire, who doesn't have any knowledge regarding the transaction. He was examined, and to corroborate the say of the deceased plaintiff and the legal head of the plaintiff.
In Marshall's case, bank manager was examined.
Yes, sir.
But in this case,
No witnesses to corroborate the say of the plaintiff. Sir, in Marshall case, the transaction was done by bank to bank, check, draft. Even then, the bank manager was examined, sir. And other witnesses also examined, sir. Even though the transaction was through check and draft. So what I mean to say, that here only cash deposit, cash withdrawal. So, sir, here the plaintiff seeks a relief from the court and to apply the theory of presumption and assumption, sir. So, which is not permissible, which is not totally logical or lawful, sir. Sir, if the plaintiff would have paid the consideration through check or draft in the name of the seller, then the certainly could have been 100% absolutely a perfect case for the plaintiff to show that I'm the owner, I purchased in the name of my father, then sir, I certainly would have no case. I must have been kept out. Therefore, sir, this judgment also is not applicable and helpful to the arguments in the case of the plaintiff appellant, sir. Because, sir, in support of plaintiff, no witness was examined regarding transaction between the plaintiff on one hand and the transaction which happened in the name of my father, sir.
yes.
Then, sir, the second judgment, my friend relied upon is the of Bhagwat Lal and Rajnath Kumar versus Singh Charan Lal and Shyam.
Patni Dhanji Shayabhai.
No, sir. So that was on the line of for the sake of this contempt.
એના પહેલા
Yes, sir. Number 2. Bhagwat Lal and Rajnath Kumar versus Singh Charan Lal and Shyam.
yes, yes.
Sir, in this judgment, the dispute was between brother-in-laws. Means एक तरफ 6.5 एकड़ बने हुए, sir. Means they are in a close relationship, sir. Now, sir, here also, sir, kindly turn to page number 3 of judgment, sir. Para 8, sir.
Para 8.
Yes, sir. Page number 3, para 8.
Sri JPF Gohil.
So, ninth line from top, sir. It starts from the very fact that.
It starts from?
Ninth line from top, para 8, sir. It starts from the very fact that he produced these documents before the trial court.
મારામાં તો પેરા 8 છે JP Gohil Learned Senior Counsel.
Sir, એમાં is para, sir, ninth line. Ninth line, sir. From top, sir.
9. The very fact.
Yes, sir. The very fact that he produced this document before the trial court goes to prove that he had actually purchased the disputed property by passing of the sale consideration. Then the trial court rightly held that that had the property been purchased binami, a collateral document would have been certainly prepared between the parties. So that's what I'm trying to convince the court. Sir, 263 purchased in the year 73. Father expired in 75. There were 2 years time for the plaintiff to take this collateral document. કે પૈસા મેં આપ્યા છે, નામ તમારું છે, ઓનરશિપ મારી છે. If sir father would have, then sir the plaintiff has got absolutely 100% right case over here. But that is not been done. That sir, mother lived for 15 years. Mother passed away 90. Sir, after father, mother was the only person who could have. But plaintiff is not doing anything, sir. Not getting this document, sir. Then the further, sir, the defendants would have got a written document executed containing admission by the plaintiff about the transaction being binami. Besides that, the document, namely sale deed, site plan, and receipt of sale consideration was all produced by such person. But sir, here in my case, not a single document to corroborate the say of the plaintiff that he paid or the father paid 6,000 rupees was of my money. Neither receipt from the seller, neither confirmation from the mother, nor from the 3 sisters, 3 brother-in-laws, sir. These 6 persons are still alive, sir. There's a further.
That was the contention of the learned advocate. પછી એ કોઈ કર્યું છે, કોઈ કોર્ટે લીધું છે એને કન્સિડરેશનમાં? પેરા નંબર કયામાં લીધું છે?
Yes, sir. Then sir,
કોલેટરલ ડોક્યુમેન્ટ માટે.
ha. Then sir, page number 6.
કોલેટરલ ડોક્યુમેન્ટ માટે પેજ નંબર 6.
ha.
પેજ 5 મૂક્યું છે, 6 નથી મૂક્યું.
So I'm referring the judgment of Bhagwat Lal and Lal Kumar versus Sricharan Lal and Shyam.
ભગવતલાલ I'm talking about. ભગવતલાલનો 5 નંબર સુધી છે.
I'm sorry.
Para number 20. In facts of this case, as per the settled proposition of law, being prospective in nature, even otherwise, I do not find any matter in this appeal accordingly.
That's the page number 7.
Page number 24 છે મારામાં.
No, sir. Here, sir, what I got it from the computer screen, sir.
તમારે વાંચો ને, last paragraph વાંચો.
Sir, last paragraph.
It starts from in fact of the case.
That is paragraph 24.
24.
Sir, any upar જ છે 23, 22. I'm guessing 21, sir. 21.
21. In the present case,
Yes, sir. Yes, sir. Yes, sir.
plaintiff was indeed the close relative of the
The
defendant.
defendant woman, if not by blood, at least through his wife, who has plaintiff, dear sister, Amuli Jay, insurance of the sister of the plaintiff woman and wife, defendant, support of the case of plaintiff also. She has stated that also. So what I mean to say, here in this case, a witness came to the support of plaintiff. But in instant case, sir, on hand, the plaintiff is not examining anybody. That he failed to obtain a document of collateral or confirmation from father Then mother also for 15 years. Now, sir, if we come to the point that of dispute arose after mother passed away. 90, 91, whatever. Cancel date also, sir. 91 and 25, 35 years. Cancel date, sir. 3 sisters, children is all still alive, sir. Sir, the suit was filed in 91 and the judgment was passed in 2015.
I'm not talking about that.
So,
Who is privy to that transaction? Sale deed. જે પૈસા આપ્યા છે. Who is privy to that 44 number?
What the plaintiff says, the consideration is paid by him.
44 માં જ.
44 માં, yeah.
એટલે 44 થી જ અહીંયા આયા ને.
હા.
See, 44 માં જો પૈસા આવ્યા હોય.
Sir, that is the case of plaintiff.
Exactly, that's what I'm asking.
But the
Who was privy to that document? Only he can depose, no?
Yes, sir. Yes, sir.
He is talking about 44 only. 44 માં જ પૈસા આપ્યા તમે.
હા.
એ 44 થી એ વેચી રહી આવ્યો.
Now, sir, if we peruse the now, sir, we do this fact. So the plaintiff has put on record only the index 2 of the document of 44.
શું કરતા હતા? સવારથી કાલથી થઈ ગયું હતું ને તમે ફોટા પડીને મોકલ્યા હતા ને. છાપામાં થતું છે ને.
પ્લાન્ટ અત્યારે આવ્યો.
કેટલા વાગે આપ્યું?
3:10.
બિલ પહેલા બન્યું?
એ પછી આવેલી આપણા ગ્રાન્ટ નો અત્યાર સુધી ફાઇનલ પ્રિન્ટ નો નીકળ્યા.
હા તો નાખીને તો બધું નાખીને
એ તો તૈયાર થઈ છે બોલો.
સારું થોડી વાર થયા.
કેટલા વાગે ઉભા રહ્યા? 3:30 સુધી જ લેશે. કેવડા વાગે ઉભા રહ્યા છે?
છેલ્લા. Just one second. No? There's an urgency. I think.
Sure, please.
Yes.
So my submission is that for 44 number plot, the plaintiff has submitted only the index 2 of the document, not the entire document. And sir, the plaintiff
Entire
Appellant.
document in.
appellant, sir, insists the court
Wait, can't say no.
to corroborate Exhibit 91 passbook along with the documents.
Document of conversion.
So Exhibit 95 is the index 2 of plot number 44 in the name of father.
90.
95. It shows that the plot is purchased by Father Koromal for rupees 1200. So what is 95? It's an index 2.
ફૂલમુક્તિયાર પાસેથી.
No.
ઠીક છે ને?
No. So it is like this, index 2. 90, exhibit 95. So that is 96. The document the father nomination for the dispute quarter 260.
હા, 90.
Just add to the document, sir. It's a single page document. Index 2. Anukramnika number 2. Got it, sir? Sir, now the plaintiff wants to corroborate this document for purchase in the name of father for 1,200 rupees. Sir, it is on record that Exhibit 91 he relies upon. That is sub 91 is the passbook of the plaintiff. That on 20th September 66, he withdrawn rupees 3990. So now kindly come to Exhibit 91, sir. That's a passbook. 91. 91.
94 Susha.
Sir, 94 is documents regarding construction on this plot.
Kaya plot over?
It is a 263, sir.
મકાન કયા મકાન?
It is 263.
આજે તો પછીનું મકાન છે. પછીના મકાન.
Ha. Now, sir, kindly turn to Exhibit 91.
એક જ મિનિટ.
Sir.
નિયમ છે. મકાન પેશગી અંગે 94 ઉપર આવો તો મકાન પેશગી
Yes, sir.
SG and ST 35
AG account number ST35.
અંગે કન્ફર્મેશન માટે વ્યાજ ગણતરી પત્રક મકાન પેશગી.
Sir, by production of this document, the plaintiff wanted to convey
which year was that purchased in 95?
66. Plot was purchased 66 and quarter 263 is purchased in the month of March 66. Sorry, 73.
જણાવે છે કે
263 in the year 73.
એ મકાન પેશગી અંગેના વ્યાજબી કપાત વ્યાજના કન્ફર્મેશન અંગે મુદ્દાઓ.
Now, sir, if we peruse 94, nowhere it is mentioned that this document.
એક જ મિનિટ સાહેબ, એક જ મિનિટ.
Sir.
HB એડવાન્સ શ્રી LK મુલતાની account
Mamdani, that is plaintiff.
plaintiff.
Yes, sir.
Amount of advance rupees 12,000 drawn by this.
So it is admitted fact on record that plaintiff Lalchan, this is LK Mamdani, had his own house. He was having own house. So, sir, this 94 also cannot help the plaintiff to show that this amount and the 100 rupees per month was deducted for the loan, whatever like he paid, was used for 263. So nowhere in this document is mentioned that this amount was obtained as a loan by the plaintiff for whatever 263. Neither the officer or a person from this department, along with the application of the plaintiff.
રાજકોટ 6,95 છે.
Yes, sir.
73 તો શું છે?
So હપ્તા કપાય છે ના એ બતાવવા માંગે છે. That from March 73 100 રૂપિયા લેકે then 70 rupees લેકે હપ્તા કપાણા અમારા.
When was it bought on?
73. But sir, nowhere in this document is
ના, એ તો ના જ હોય.
then sir application sanction થઈ loan માટે, no officer, no witness, no person from the department. Sir, those must have been a ace in this suit. They must have shown or thrown the light and certainly absolutely would have supported the case of plaintiff.
What was the value?
Value?
A time?
Value?
Amount advance rupees 1,200 and 12,360.
12,000.
Right. What has the court said about this?
Nothing.
Court की बात है nothing.
Nothing. Because the plaintiff didn't know this document.
શું prove કરવાનું? This is a government document.
Okay, sir, but how it's applicable to this case?
ના પહેલા તો કેવું પડે કે it is not applicable to the case.
But sir, the burden lies on
કોઈએ
plaintiff.
કેવું પડે.
Sir, the burden lies on plaintiff.
આ તો કોર્ટે કેવું પડે the burden lies on the plaintiff, he has not proved and therefore it is not taken into consideration.
Because that was not the issue. So
It
the
was
court,
the main
court-
issue
court-
એ જ હતો.
Sir, I understand.
Issue તો એ જ હતો.
Sir, I agree. But the burden of the plaintiff is not discharging.
તો કોર્ટે કેવું પડે કે it is not discharging his duty as this and therefore this evidence is not taken into
No,
consideration.
sir, the.
આપ સમજ્યા ને?
Sir,
મારું એમ કે something has to be discussed.
Sir, I got a point, but the court is silent on that point, sir.
એ જ problem છે.
Because sir, that
કોર્ટ
was.
જ્યારે સાયલેન્ટ થઈ જાય છે ને ત્યારે વાંધો આવે.
Sir, yes, sir.
બાકી
But sir-
વાંધો નહીં.
But sir, this document and the content of the document is not referred in the plaint also, sir.
આ 66 નું ડોક્યુમેન્ટ છે એ કયું છે?
96, exhibit 96, sir.
એક 66 છે.
Yes, sir. No.
92. આ 92 શું છે?
So 92 is
લાલચંદ કોરમલ મમતાની.
the plot number 36 purchased by plaintiff in his own name.
Hmm.
That is 92.
Hmm.
Sir, I was referring exhibit 91, the passbook of the plaintiff, sir.
Where is the original document of his father's name?
Sir, in cross examination, the present appellant, higher of this Lalchan, admit that I have the possession, I will produce it, but not produce. Sir, in Manoj judgment, sir, of the Supreme Court, which my friend relied upon,
You don't have it?
you sir, we don't have,
So who has it?
nobody. As per my knowledge, my client's knowledge, it is not with the plaintiff also,
તો કોના પાસે છે?
third party.
કોણ થર્ડ પાર્ટી?
I don't know, sir, I have to search out.
કોઈએ તો કેવું પડે ને કે આ ડોક્યુમેન્ટ
હા.
ક્યાં છે?
But sir, a very specific question was put to witness, this Ramesh. My પાસે છે, હું આપીશ. The suit was disposed. Thereafter, sir, I served a notice to this Ramesh. My friend replied, we have filed appeal. In appeal now, the matter is subject. We will not show you. I said, હું પણ જોવાના છું. How much legal have? I want to see. Okay, you present it. Sir, to show the
એક
genuineness,
સંમત
ownership.
બરાબર શુક્રવાર. Who are the signatories here? અમરતલાલ પુરુષોત્તમ દેવ.
Which one, sir?
આ ક્યાંથી પરચેસ કોના પાસેથી કર્યું છે?
Which one, sir? 96?
96 નું ડોક્યુમેન્ટ. 36 અને પ્લોટ નંબર 3644 ની ચોમસવાર રાજકોટ શહેરમાં આવેલ છે મિલકત ના વેચાણ દર્શાવે 1200 રૂપિયા રારા લાલચંદ કોટમલ મમતાની હિન્દુ નોકરી કરી આવશે. બરાબર છે. જો લખી આપનાર મગનલાલ હરગોવિંદ ત્રિવેદી ધર્મે હિન્દુ ફલાણા ફલાણા.
Yes, sir.
મારા સુવાંગ કબજા ભોગવટા અને સ્વતંત્ર મકાન અને સુવર્ણ હકીકતે કે મારા સ્વરૂપે પડતર જમીન રાજકોટ ડિસ્ટ્રિક્ટ રાજકોટમાં
Refugee colony, sir.
આવે છે.
Housing authority માં આવેલ છે.
સદરહુ જમીન પ્લોટ નંબર 36 અને 44 ના મારા નામના એક નંબરની
Book number 1540, volume 2 to 1.
60 થા નોંધાયેલ છે. બંને પ્લોટ એક જ બુકમાં નોંધાયેલ છે.
No, sir.
નોંધાયેલ વેચાણ
Maganlal
દસ્તાવેજ
purchased by one document, 33 to 44.
હા એટલે જ તો
Yes, sir. Yes, sir.
આ સદરુ જમીન પ્લોટ નંબર 36 અને 44 ની ચોરસવાર દિસમચ
Yes, sir.
મેં મારા નામના એક નંબરની
In book number 1540, volume 2 to 1 માં, this now signed.
વેચાણ દસ્તાવેજથી શ્રી કૃષ્ણ હાઉસિંગ સોસાયટી લિમિટેડ પાસેથી વેચાણ લીધેલ છે.
Yes, sir.
તેનો વેચાણ દસ્તાવેજ મજકૂર સોસાયટીના પ્રમુખ પોપડો સાંજના ટાંકી કરેલો છે.
Means the Maganlal purchased by one document 2 plots.
સદરુ જમીન
માહિતી plot number
માહિતી
33,
પ્લોટ નંબર 36
પશ્ચિમ દક્ષિણ કાનપુર જમીન 24/134-6/0.
સદરુ તમામ વેચાણ જમીન દિસમચ છે.
So this is for 1200 rupees in the name of plaintiff.
Yes. And both the documents are of the same date.
Same. Now the kindly come to
બીજા
exhibit 91, sir.
ખાલી એને કબજો તેને સોંપી આપવામાં આવે છે. તે તમારા પુત્ર પેટ્રિક લાર્સન સોંપી ભોગવે મીટર હકો હિતમાં મેં તેમને વેચાણ આપી તેના ખાલી કબજો મેં તમોને સોંપી આવ્યો છે. તમો કદોરી તમોને વેચાણ આપેલ જમીન ઉપર નામદાર સિદ્ધ સરકારનું નથી. કદોરી નામને વેચાણ આપેલ જમીન આ તમને વેચાણ આપેલ જમીન કાગળો નીચે છે. ટોક નંબર દસ્તાવેજ મદર વેચાણ દસ્તાવેજ જો કરી આપેલ તે નંબર દસ્તાવેજ બાકીના ચૂકતી September 66 by Sunilal Sambar Doshi. તાણું કીધું છે પતાણું લેઆઉટ પ્લાન.
Exhibit 93 is the plan of 36.
પ્લાન ઓફ
Plot number 36.
તો ઘણા બધા પ્લોટ.
Therefore, sir, it can be inferred from the exhibitors.
આ બે બાજુના પ્લોટ છે.
No, sir.
અલગ પ્લોટ છે.
So actually, as per the sale of the plaintiff, he purchased 2 plots, 36 in his own name, 44 in the name of father. And he says that consideration is paid by me. Now, sir, kindly come to exhibit 91, sir, the passbook of the plaintiff, which will clear the ambiguity, sir.
Exhibit
91, sir, the passbook of the plaintiff. The last 2 entries. One is of withdrawal and one is of deposit. Now, sir, it shows the deposit of 1,000 on August 4th, cash. And withdrawal of rupees 990 on 28/9/66. Now, sir, we can very well assume that in the year 60s, the salary of a person's was a meager, not more than 50, 60 or 70. How he got this 1,000 rupees? That's what the defense of defendant, sir.
One date, what date?
August 4, cash 1,000. Sir, that is the main defense of the defendant, that out of the joint funds of the family members, father, this Lalchan and dependent, and the brother who
કેટલા
expired.
ભરવાના હતા?
Sorry?
કેટલા પૈસા આપવાના હતા
કોને?
આ જગ્યા લેવા માટે?
6,000. 6,000. Means 263 to 6,000.
1200 ને?
Yeah.
2400.
Sir, that is for 36 and 44.
એની જ વાત કરું છું. આપણે આગળ તો જવાનું જ નથી. વી આર ઓનલી અત્યારે ક્યાં છીએ આપણે?
Okay, sir.
વી આર નોટ. પેલું તો બહુ મોડું આવ્યું, 95 માં આવ્યું ને? ના, આઈ થિંક ઇટ કેમ ઇન 73.
73.
કયું?
263.
263.
Yes, sir.
હમણાં તો આપણે 66 વાળી જ વાત કરીએ છીએ.
Okay, this means your 2 plots.
બે પ્લોટ્સ. એ
36
ક્યાંથી આવ્યા?
44.
એ ક્યાંથી આવ્યા છે?
Okay, sir.
બસ તો એ ડિસાઈડ થાય ને, એના માટે શું છે?
Sir, 1,000 rupees is the joint funds of the family members.
આ કઈ તારીખે જમા થયા છે?
August 4,
1970.
1966. 1966.
August 4th August
Yes, sir.
1966.
66.
That time you didn't have the income also. Joint family માં ક્યાંથી આવે?
Not me, father.
હા, એટલે જ કહું છું, ફાધર ની વાત કરું છું.
Sir,
That claim has not yet come. You said next માં તમે એમ કરીશું. આજે લીધો ને કયો? આ રેવા.
73. Now, sir, kindly tell only 2 documents now of sale of my father, sir. Sir, first one, this 263, which is disputed one, sir. It will make the picture clear, sir.
Which one?
96 for 263.
96.
Yes, sir. What is this dispute has been going on?
Huh, 96.
Page number 1. Third line from bottom, sir.
જોગ લખી આપના
No, 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 no. Very first page, sir.
અચ્છા, બસ ભાઈ.
Sir, in new budget, નામ આવે છે. The name of my father appears.
શ્રી કોરામ.
Salomat Pamandas, Dharma Hindu, so and so, Sindhi, Lohana, Umar was Sinkar, Dhando Vepa.
Right.
Sir, my father was doing business.
Hmm.
But sir, it is the submission on behalf of appellant that father was not doing anything. He doesn't have any income. Now, sir,
I'm not saying no.
no, sir, it was one of the submission on that
ક્યાં
day.
ના પાડું છું?
Now, sir,
કરતો જ હશે વેપાર. આમ નથી કેતો સી
sir.
આ પૈસા ક્યાંથી આયા છે તમારા જોડે? તમે જ કીધું છે કે પેલું 44 વાળું વેચીને અહીંયા લીધું છે. હવે 44 જ જોવાનું છે.
One of the contention was there that father was
that
not
was
having
the
any
only
income,
contention.
and all the consideration was paid by plaintiff.
What plaintiff? How do you? એને શું કીધું છે? કે 44 was sold out and money was given you. 44 was sold out for 5,690.
Finally.
And he gave 6,000 rupees.
Yes, sir. Yes, sir. Yes.
6,000.
Yes, sir. Yes, sir.
That's all.
Yes, sir. Now, sir, in this line, sir, kindly see the document which is produced by the legislature on last date that he sold out this plot number 44. In this document also, sir,
It's that page.
the page that
Exhibit.
the exhibit is, sir, I am the 4127 this, sir. He sought the permission for producing this because the query was here by this court. That where is the 44 document number?
એ ભાઈ ક્યાં છે? અપીલ ક્યાં છે? અપીલ
Now we see the appellant, the same thing.
અપીલ અપીલ.
Documents and documents. You find alert here, sir. So that will not be in the record of the lower court.
અપીલ અપીલમાં.
Appeal was ordered.
અપીલ તમારે જોડે છે ને? કાઢો એ અપીલ. 41 વાળો.
Take a copy of the same date. Obtained from the sub-register office.
Exhibit કેવી છે?
No, exhibit નથી. I am here, appeal.
ફોટોગ્રાફ અને અપીલન્ટ દ્વારા
એના પૈસા document આવે છે.
32.
Yes, sir.
Exhibit 32.
The fourth page from the document, and it shows the page number 192.
31. Okay.
Report છે.
એના પછી, sir. It's in handwritten manual, sir.
manual.
Now, sir, page number this 192. It was 192.
192.
Yes, sir. Now, sir, 8 line from top. 8 line. So when you must have naam बतावे छे लोग.
What's your name?
The name of my father.
Watch.
Sorry.
મને બી વંચે તો
Sir, it starts from જોગ લખી આપના રાજકોટના રહીશ્રી કોરોમલ પવનદાસ મામતાણી ઉંમર વર્ષ આશરે 66. પછી તો બહુ લેજિબલ નથી સાહેબ. I'm unable to read.
સની
હિન્દુ લોહાણા સિંધી ધંધો વેપાર.
વેપાર.
Sir, my father was doing business.
ના ક્યાં પાડું છું?
Sir,
નથી ને બરાબર.
because sir, that day it was reiterated again and again that father was not any income. All the
That doesn't
consideration-
matter. I'm not even going into it.
Okay, sir.
I'm going into 44
No, no,
only.
good. I'm good.
44 કેવી રીતે લીધું છે?
Okay, sir.
That is the crux.
Okay, sir. Okay, sir.
44 વેચીને તો આ લીધું છે.
Ha. Now, sir, the document for 44 is not coming into the picture. Only the index has been produced over here.
44 મંગાવવું પડશે. મંગાવી લો.
Then, sir, if we collaborate 91 with the 44 and 36, sir, so 36 consideration 1200, 44 consideration 1200, and he withdraws 3990. Then where the rest of the money goes? No explanation, sir.
What was required to be paid for the plots?
2400.
How much did he have prior to that? Prior to depositing 1000?
Nothing.
હતા.
Just rupees.
2900.
No, no, no. Yes, 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 sir. Yes.
2400 આપવાના હતા. 2900 પડ્યા હતા. 1000 રૂપિયા પાછા આપી દીધા હશે.
But sir, 1000 is
ક્યાં ના પાડું છું? એ આપે તો
joint
નથી.
fund
2400
of
માં
the
આપે.
family.
માની લઉં છે. એના અકાઉન્ટમાં કેટલા હતા?
Yes, he was having 2936.
2400 આપવાના હતા.
But sir, what was the cause?
But you don't have, see, જેમ કે તમે કીધું કે 1000 રૂપિયા ક્યાંથી લાયા? માની લો લાયા બી હોય. But it is not used
Sir,
yet.
sir, this is my defense. That this is money of joint funds, joint
But
family.
it was not required to be used. ના આપ્યા હોત તો કઈ વાંધો નતો. 2900 રૂપિયા તો પડ્યા જ હતા પહેલાથી. 2400 રૂપિયા આપવાના હતા. આપી દીધા.
Yes, sir. Yes, sir. Yes, sir.
That
Now,
is what
sir,
I am saying.
Now, sir, for this documentation, sir, kindly, sir, turn to exhibit 109. 109, sir, the deposition of present appellant, Ramesh.
Yes.
Page number 7, sir.
Type કરો.
Page number 7, in the cross, sir.
102
109.
9 છે. હા. 109 માં
Page number 7.
4 5 7. How do you say 7? Yeah, single છે.
Sir,
આ 2 નંબર છે. પહેલો પેજ ને 2 નંબર
sir,
આપે.
sir, no, sir. After 3
7.
cross,
5 6 7. Yeah.
I'm just cross.
આ તો તમે મને વંચાયું હતું ને લાસ્ટ ટાઈમ.
No.
હા.
It was left out, sir. Sir, page, line number 9 from top, sir.
હા. 1 2 3 4 5 6 7 8. હા વાંચો. 36 અને 44
Ha.
કરવા માટે
Now, sir, it starts from here. એ વાત ખરી છે કે આ બાબતે મને અંગત જાણકારી નથી, પણ હું રેકોર્ડના આધારે કહું છું. Then further, quarter number 263 નો અસલ દસ્તાવેજ મારી પાસે છે, જે હું રજૂ કરીશ.
ના ના હું તો 44 નું માંગુ છું.
Sir, what I'm showing, sir, the difficulty which I had to face.
44 નું નથી મૂકેલો ને.
Sir, I wanted to ask many questions to the present appellant Ramesh, but the court says he's third party because he hasn't done anything. All transactions, everything was done by Lalchand. He's no more. We will refer, we will presume, we will interfere in the arguments. Therefore, sir, the documentation of the plaintiff over here in the name of
44 નું ડોક્યુમેન્ટ ક્યાં છે? તમારા ફાધર ના નામ.
so, it is my father. He's the appellant. So I'm sorry. I'm sorry.
44 તો તમારા ફાધર ના નામ નો હતો
It
ને.
is sold out.
આ એ ડોક્યુમેન્ટ ક્યાં છે?
So, must have been in the purchase.
હા એને કોપી તો હોય ને.
હા. But
પેલા સબ રજિસ્ટર માંથી
હા,
મળી
હા.
જાય. એ લાવ્યું હોત તો બધું ખબર પડી જાય.
yes, sir.
પણ કઈ ડઝન્ટ મેટર ટાઈમ.
Sir,
Only matters.
sir, what I'm trying to submit that in the lower court, sir, we do inspect, sir. with due respect, if I'm wrong, sir, I may be permitted, sir, I may assume that the court says he's third party. You can't ask the questions for the person other than this witness. You stick to the questions pertaining to him, whatever he knows. He clearly says, obviously, he doesn't have. What his father have done in the 60s. Therefore, sir, regarding the documentation over here, I was restricted. Sir.
I restriction I see this is verbal, na? It's like problem ત્યાં થાય છે.
But sir, this is the
At least, you should have said, sir, please note it in the deposition that this court has asked me to
I
ask you.
understand. I agree, sir.
That would be an intelligent lawyer saying
but-
that કે ભાઈ આવું કરી નાખો,
But sir, it
કાલે ઉઠીને
differs
થશે.
from court to court.
No. એટલે sir, please record
Yes,
this
sir,
because
yes,
it
sir.
will go against me.
Sir, now I have developed that tendency because of now I also appearing in the High Court. So High Court clearly says, બીજી કોર્ટમાં છે, પૂછ્યું છે, નથી પૂછ્યું. So the first time here, we will not entertain. Strictly no. That's why I asked to all the courts, if you disallow a question, I don't mind. Let it be on the record so that I can urge in the appeal to the High Court. They will interfere this. They will resume this. Therefore, the plaintiff has visibly failed up to the satisfaction of this court to convince that 263 is being purchased from his funds in the name of father. Now, sir, I was referring the one of the judgment of Bhagwat Lal, sir. So very clearly, the Supreme Court has held may I read two lines, sir. As regards the original title documents being found in possession of the plaintiff, the subject of the appellate court has held that the plaintiff had taken away the original sale deeds from a so. Meaning there, sir, if the plaintiff says he is the owner, father is just a fiduciary relationship, trust, sir. Then this only document must have been with the plaintiff. He is not coming with the plaintiff, with the original document, sir. Cannot I say, sir? As the plaintiff is not the owner, plaintiff hasn't paid the consideration, therefore he doesn't have this document in his possession. And is playing the game. Regarding issue number 1 in the lower court, the lower court judge has very categorically in detail has observed from page number 13 to 20, almost in 8 pages, sir, and lastly held that the plaintiff fails to prove his ownership for them to see, sir. In detail here, sir, he has discussed the judgments of the plaintiff, which are also referred over here. The provisions of William transaction 3, 4, 2. And so interesting, so once a plaintiff purchased plot in the name of father, why again purchase in the name of father? He could have, he must have purchased in the name of wife, children. Once it's okay, but repeatedly, what was the reason?
In 73, did he purchase any other place?
No.
Why did he take a house loan?
For 36. For 36.
36 was purchased in 66.
That was the plot, sir. He obtained a loan for construction of 36. Not for using this 263.
That any evidence you placed
No,
on
nothing,
record?
nothing.
No, you
So I don't have.
you disputed it.
I can't have. Yes.
You disputed
Sir,
that
sir,
fact.
I wanted to. The court restricted me. No. He's third party. He doesn't know. He's not the person who dealt with, who knows, he doesn't know. Specifically, he says, अब मैंने कहा जानकारी नहीं थी. Maintenance, the lower court.
ના ડોક્યુમેન્ટ 73 વાળું 73 નું જે લોન લીધું છે ને
हाँ हाँ.
એની વાત કરું છું.
अच्छा, loan was obtained by father. How the son can say
આ
after
નથી
30, 40
કહેતો.
years?
એના પછી તમે એમ પેલા જો એમ ક્લેમ કરે it was for father. Have you placed anything on record to show that it was for 36 not for 256?
Sir, what my nothing. When he doesn't know anything, so that's the irony and difficulty with the. I'm sorry, but sorry. This is the problems we face.
There are many problems. I would say yeah, there are many problems.
Yes, sir. But sir, the lower court has from page number 13 to 20.
No, that I understand. That I
In
see.
detail, sir. And that will, because sir, that's the main issue. When the or rather the point of dispute between the parties.
I understand that. Let's see. Anything else?
Sir,
Let's
so
see whether BJP training.
appeal doesn't survive and there is no scope for this court to interfere with the findings of the lower court, which are absolutely and legally, lawfully and genuinely on the law points discussed in detail. And in appeal also, sir, the appellant failed to show anything contrary to the findings of the lower court. Then why this court should interfere and modify or try to satisfy the order of the lower court? Is it because of nothing on the record to show contrary other than what the lower court found and observed and concluded? Sir, that would give me sufficient time to submit.
I had to. બે આ મૂકી દો ને. Order ઉપર લઈ લો.
So I'll be here if any query, any.
No, definitely.
Whatever.
When I'm writing, I'll
Okay.
follow up.
I'm there too, sir.
Okay. પેલા સાહેબ આયા પેલા એમાં શું સમાધાન કરવાનું છે? એ જતું ને? ચાલો. Yes.
આપની પાસે મોટા આપણે એવું કીધેલું કે પોલ વેલ્યુ ત્યાં ફાઇલ કરવી છે. સમયવાળા જેમની પ્રોપર્ટી છે અહીંયા લોકેટેડ નથી અમદાવાદ છે એવું કીધું ફાઇલિંગ મને અહીંયા કરાવવામાં કોઈ ઇસ્યુ નથી. પછી મને ત્યાંથી નીચેથી ઉપર કીધું કે સાહેબનું કન્ફર્મેશન લઈ લો. મેં કીધું સાહેબે ત્યારે જ કીધું કે આ પોલ લઈ લો ક્યાં ફાઇલ
મારે કઈ વાંધો નથી મૂકી રાખો પછી હું એક્ઝિક્યુટ કરું છું બજાવવા માટે ત્યાં નહીં જાય કોઈ બી આઈ એમ સોરી પછી તમે તમારા હિસાબથી કરતા રહેજો બટ નો ઇશ્યુઇંગ ઓફ વોરંટ ધીસ થિંગ
ના સર ત્યાં સુધી પરિસ્થિતિ આવશે તો હું તો એવું આપને નહીં કહું ડેફિનેટલી બટ સર મારી અત્યારે કન્સર્ન ખાલી ફાઇલિંગ છે સર કે અહીંયા હું ફાઇલિંગ કરી શકું
થઈ ગયું ફાઇલ
એટ ધ ટાઈમ ઓફ ધ અટેચમેન્ટ ઓફ ધ પ્રોપર્ટી
અટેચમેન્ટ આપવાનો જ નથી હું આઈ એમ નોટ ગિવિંગ યુ અટેચમેન્ટ એઝ સચ આઈ વિલ ગિવ યુ નોટિસ ટુ ધેમ નોટિસ ઇશ્યુ કર દે પછી જોઈશું but you should not be doing it here. You should take a transfer of decree from here because it is there. Because I have not taken my hand on any of the judgments. Right now, I wouldn't obstruct you from here. But since
so the section 38 and
of
CPC,
section 38,
section 38 and order 21, rule 10, both are very much in
order 21 rule
10.
21. Okay. Order 21, one more than 20. Application for execution. Where the holder of a decree desires to execute it, he shall apply to the court which passed the decree or through the officer, if any, appointed in this behalf. Or if the decree has been sent under the provisions herein before, contained to another court, then to such court or to the proper officer thereof.
It means, sir, he has an option. Yes, sir, either though he can file to the court which has passed the
Oral
decree.
application, where the decree is for the payment of the money, the court may, on the oral application of the decree at the time of passing over, order immediate execution thereof of the arrest of judgment debtor prior to the preparation of warrant if he is within the proceedings of the court. Presence of the court, within the presence, by the presence, the matlab sushi, PRE, lucky na PRECINCTS.
Sir, please, section 38 पर sir paper आपने कर ही रही है.
एक मिनट. Save as otherwise provided, every application of the execution shall sign by name of party, where any appeal before is passed, whether payment. The court to which then application is made under subgroup 2 may require applicant to produce a certificate of application of arrest. Where an application is made for an arrest or detention, application for attachment, where an application is made for an attachment of a money movable belonging to a judgment debtor, but not in the decree of the shed, annex the application and inventory attaching, converting, a clear description of the same. Application for attaching which contains certain particulars. And immovable belonging to the judgment debtor, it shall also contain power to require certified extra from collectors registered in certain applications for execution by joint decree or application for execution by transfer decree. Whether a decree or if the decree has been passed jointly in favor of 2 or more persons, the interest of any decree holder transferred by assignment in writing operation is provided that where the decree of has been transferred by assignment on receiving application for execution, the court shall ascertain whether such of the requirements of rule 11 to 14 as may be applicable to the case have been complied with. And if they have not been, the court shall allow the defect to be remedied within a period of 6 weeks. Enter, register the note, provide that in the case of decree in the money, the value of the property shall be able. Execution of cross decrees, cross degree. You are saying which section?
Section 38. 38 to 40 of all consonants of 21. Section 38.
Warrant of arrest to direct judgment debtor. 38.
See, sir. 40 by decree may be executed.
38 my own fancy.
38.
Arrest and detention in civil prison. Orders.
Section 38.
Judgment. Order 21, section 31. Section 38. 38. Court by which degree may be executed. 77. 77. Court by which degree may be executed. A decree may be executed either by the court which passed it or by the court to which it is sent for execution. Who sends it?
Court only.
Court only sends it. बस बस
After
काम
my
करो.
application, sir.
Admission करना, admit करना को.
जी सर.
અને પછી તમારે મોકલી છે ત્યાં જ.
સર એના પછી સેક્શન 39 છે સર. એ સર આપ જે કહો છો ને સર સેક્શન 39 ટ્રાન્સફર ઓફ ડિગ્રી.
હા, તો એનાથી શું થશે
The
પછી?
court which passed the decree may, on the application of decree holder, send it for execution to another court. On the application of decree holder. I am right now sir concerned with filing only. એટલે હું સર ફાઇલ અહીંયા થઈ શકે એવું મારું સર હમ્બલ સબમિશન છે.
ના ના, અહીંયા કરે પછી
અત્યારે જ્યારે પછી અટેચમેન્ટ ની કે એની વાત આવે સર,
ફાઇલ તો કરી નાખું છું, નંબર પાડી દો, પછી
તો કોઈ ઇશ્યુ નથી સર.
પછી શું કરવાનું?
જ્યારે
નોટિસ તો નહીં કાઢું.
બધી મેટરોમાં સર છે ને અટેચમેન્ટ સુધી પહોંચતું જ નથી સર. એને નોટિસ શો કોઝ નોટિસ
નોટિસ શું કરવું છે કરીને તમે કરી આવજો કે ભાઈ ફાઇલ થઈ છે.
તો સર હું એમને ખાલી નીચે હું કહી દઉં છું કે ફાઇલિંગ માટે સર એ ફાઇલિંગ પણ અહીંયા નથી કરવા દેતા એવું છે.
હે,
ફાઇલિંગ ની પણ અહીંયા
એ ના જ હોય, કેમ કે અહીંયા બીકોઝ યુ હેવ એન ઓપ્શન વેર યુ કેન હવે પછી ટ્રાન્સફર કરવાની, પછી આઈ હેવ ટુ અગેન ટ્રાન્સફર ઇટ ટુ ધેટ કોર્ટ વેર ઇટ ઇફ ઇટ ડઝન્ટ અપિયર, વોટ વિલ યુ ડુ? ક્યાં જશો? Why are you burdening this court just for your sake?
એવી નથી સર, પણ અહીંયા jurisdiction બની છે એટલા માટે સર.
અરે ક્યાં ના પાડું છું, but you are trying to burden this court. છે જ ને, because you have an option. અહીંયાથી ટ્રાન્સફર લઈ શકે છે ને ડિગ્રીનું. Give an application, I will transfer it there.
સર એ તો કોઈ ઇશ્યુ નથી સર. કદાચ અહીંયા આપ સર ના પાડશો તો કઈ મારે અહીંયા ફાઇલ
ના, નથી પાડતો. I said I'll admit it, but you are burdening it for no reason at all. For no reason at all. But then again, જો ના બજે તો શું કરશો? You will come for transfer of degree.
એ સર હું સર 2114 ની એપ્લિકેશન આપીશ. will file an affidavit declaring his property. એ પણ કદાચ સર એ સ્ટેજમાં પણ ક્લિયર ન થાય. We will go.
અરે you very well know he doesn't have anything in Rajkot.
જી સર.
You know that.
Yeah.
તો શું રાજકોટમાંથી લેશો તમે? You know very well where his property is.
પણ સર એટલું
ખબર જ છે ને.
સર
અહીંયા what will you get from here? Nothing. Only that the notice will go from Rajkot.
એ appear થશે. અને સર
Appear so that is a later stage.
yeah.
But what will you get from this? તો પેલી કોર્ટ બી ઇશ્યુ કરી શકે નોટિસ, ના કરી શકે.
either way છે સર. યા કરી શકાય. હું ના નથી પાડતો સર કે
તો
અહીંયા
પછી-
થાય એવું મારું
તો
શું?
why hell bent upon here? એટલા માટે અમે ઇન્સ્ટ્રક્શન આપેલા છે કે ભાઈ કરવાની જ નહીં એમ. કે ભાઈ છે જ્યુરિસ્ડિક્શન, પણ અમારે જ્યાં છે ત્યાં તો કરો ને. અલ્ટિમેટલી કરીને પાછું ફરીને ત્યાં જ આવવાનું. That's not it is very unbecoming of you people also કે ભાઈ અહીંયા ના ફાઇલ કરવી છે, આપણને ખબર હોય કે છે. અને એટલા માટે તો હવે તમે તો રિસ્ટ્રિક્શન એ કરી નાખ્યા છે કે ભાઈ સી ટુ ઇટ જ્યાં સુધી એક્સિડન્ટ અહીંનો ના હોય રેસિડેન્સ ઉપર ના આપો. That is what we are trying to do. But એવું નથી કે ઇન્સ્યોરન્સ કંપની ત્યાં નથી, કરીએ જ છીએ ને. બધી જગ્યા હોય છે, તમને કેવી રીતે જ્યુરિસ્ડિક્શન મળે છે? એવી રીતે છે. બટ એડમિશન નો તમારો રાઈટ છે, યુ આર ક્લેમિંગ ઇટ, બટ યુ આર ક્લેમિંગ ઇટ ઇન ધ રોંગ વે. This amount, which company you are?
HDFC.
And yeah, we'll have to see, Ben, not corrupt. We'll have to see that you, if you are taking it that way as a matter of right, doesn't look good on your part. એટલે છે ને, because the provision is there, I have to allow you. બરાબર છે, મારે તો અલાવ કરવા જ પડે, કેમ કે પ્રોવિઝન છે. HDFC should have thought એમની ઓફિસ નથી અમદાવાદમાં, અહીંયાથી ના ટ્રાન્સફર થાય. એક એપ્લિકેશન કરો, ટ્રાન્સફર કરાય જ ને. And it is said upon an application made by the.
But I have informed them કે આવા issues છે સર.
અને પછી doesn't matter if they want to file it here, I don't mind. અમારા શું ફરક પડે? એક વધારા નહીં મેટર. 96,000 મેટર્સ છે, એમાં એક 97 થશે, શું ફરક? But
no doubt sir,
this kind of argument by a insurance company.
I understood sir, ફાઇલિંગ કરવાની ના નથી પડતા, પણ કદાચ સર આપનો ઓર્ડર એવો હોય કે અહીંયા ફાઇલ નથી કરવાની, તો સર મારે તો
Order તો ના જ કરાય ને.
હું સર just
આપ સમજ્યા નહીં.
એડમિશન માટેની
You didn't understand my point.
Yeah.
We don't say no. It is a presumed fact that કે ભાઈ જ્યાં હોય ડિગ્રી ત્યાં કરો ને. So they would say કે ભાઈ go and tell the court about it. When we know that there is a provision, there is no written order. છે written order નથી કોઈ. એટલે કીધેલું હોય છે presumably કે ભાઈ કહેજો એમને. ગાર્ડિયનમાં શું હોય છે? ગાર્ડિયનમાં બી એવું જ હોય છે. Till the time it doesn't satisfy, આપણે નથી ફાઇલ કરવાની.
Actually એવું છે સર, there are number of executions pending before this court also. અલગ અલગ કોર્ટોમાં એમાં સર અલગ સિટીઝ ના સર છે ને જે સામેના
છે
ઓપોનન્ટ
ને,
એ
એક
સર
એને
છે. એટલે સર
એક
એવું
એને
થાય
ના
કે
ના
તમારી આટલી દરખાસ્ત ઓલરેડી પેન્ડિંગ છે, હવે જ તમને કેમ આવો ઇશ્યુ આવે છે એવું સર તમને
ફાઇલ કરી દેશું. And whatever it is, one more thing, આપણે જુઓ જંગમ વોરંટીમાં બી નહીં હોય.
હું સર આપને ફોર્સફુલી નથી કહેવા માંગતો, મારે અહીંયા જ ફાઇલ કરવી છે.
I'm not talking about you personally, I'm talking about your company.
જી સર.
Tell them why you help and એટલું બધું તો થઈ ગયું છે. Why help and upon this કે ભાઈ અહીંયા go to Ahmedabad. એમને ખબર છે કે ત્યાં હવે I have told all the courts. Jurisdiction bar no word, no non jangam warrants. Issue notice, sit down. Why issue the jangam warrants for that reason? We have already told this, and today I am going to pass a circular also. That ke bhai, our internal circular, which will be on WhatsApp, they'll all come to know. Why will we be giving them special treatment when they know they can get it transferred from here? Provision is there.
Yeah.
Still they want this court to do it. Filing, okay, filing, we'll do it. ભાઈ મને થોડું કામ રજૂ આપો.
સર મારા માટે પણ બહુ નાનું એક્સરસાઇઝ છે. એનું રીઝન છે સર, એ લોકોએ મને 15 સર દરખાસ્તો આપી ને સર, મારે પણ 15 ના સેટ તૈયાર કરી અને સર પ્રોપર જ્યુરિસડિક્શનમાં ફાઇલ કરવાના સર. મારા માટે પણ એક ખરાબ વાત છે કે મારે એમને કન્ટિન્યુઅસલી આ બાબતે કહેવું પડે છે. બટ સર they are only concerned with the CNR number. મને બસ ફાઇલિંગ થઈ જાય, મને CNR નંબર મળી જાય, ડન.
સારું લેટર આપો એમને ફાઇલ નંબર પાડી આપો. નંબર પાડે પછી મારી કોર્ટમાં મૂકી દેવાની છે. આ બધી જેટલી બી એક્ઝિક્યુશન્સ બહારની હોય, બહાર એમની પ્રોપર્ટી બહારની હોય, એ બધી મારી કોર્ટમાં લઈ મૂકી દેવાની. Then I'll see what to do. You're talking about simultaneous execution, you said? Section 34, no?
38 sir.
38 you read.
Starts from section 36. 36 is sir, onward the execution material section. The 2017 Delhi High Court નું સર એક જજમેન્ટ છે. એમાં તો સર એ લોકોએ એવું પણ ઓબ્ઝર્વ કરેલું છે કે if the property is located outside the territorial jurisdiction of the particular court, તો પણ સર અટેચમેન્ટ નું વોરંટ છે.
એમાં શું કરવા આપવાનું આપણે? મે છે ને, એમ બી તો સ્યાલ તો છે જ નહીં. એટલે if they are saying that no, we have our very much right, કરો તો પછી. If you think you can take orders from the court, જબરદસ્તી, not about you. I'm talking about the company. They're referring it to so much when they know where the jurisdiction is, property છે, બધું convenient છે, company is there. ભાઈ આવું કરશે તો પછી તો okay. માં તો અરેસ્ટ વોર્ડર છે ને ભાઈ? 38 is a warrant to arrest. Filing not jurisdiction માટેનો કયો સેક્શન કીધું તમને?
38 section. Section 38.
Section 38, 70. Section. Yes. Court by which a degree may be. A decree may be executed either by, it is not even shall, or by the court to which it is sent for execution. બરાબર છે.
37 માં definition આપેલી છે કે as far as the decree is definition of 37.
No, that is not in dispute. 69 మార్చిలో బై అకాడమీ it is read the section 39(4). Section 39(4). Nothing in the section shall be deemed to authorize the court which passed a decree to execute such decree against any person or property outside the local limits of the jurisdiction. Nothing in this section shall be deemed to authorize the court which passed the decree to execute such decree against any person. And the deeming provision be nothing. So now if you even tell me, sir, filing, thank you, now please transfer. No. Nothing is deemed to be provision. Either way you are going to get in a fix. This way or that way. You will come before me, file an application, that please transfer it now. I'll say no. Because nothing in this is to deem to authorize this court. Like deemed authorization, nothing. Even if I want to, I'll transfer. If I don't want to, I'll not even transfer it. However, this is the amendment made in later on. No, you will have to transfer it. That was used to be refer case law. It is enacted in 2002. This amendment also came in. It came from with effect from 1/7/2002. It is better for them to transfer it there only or file it there only, but doesn't matter, file it here. Number for this. એમને તો સીએના નંબર જ જોઈએ છે અને પછી મારી કોર્ટમાં જ મૂકજો. And how many days you will give the details? 105. Order 105. Details of the property. How many days you are going to give me? Rule 105. Order 21. Now the execution option. Now what do you like? Details लगे जी हमें. What do you have to write? 105 जो सूची है. क्या चाहिए details? ये तो आप ही पढ़े नहीं तो आई में डिसमिस करना है किसी फाइल करी नहीं पहला तो 105 ना व्हाट यू हैव टू गिव मी पहला 105 શું કહે છે
હિયરિંગ ઓફ એપ્લિકેશન
this one શું આપવાનું તમારે મને 4 કે 5 ચીજો કીધી છે બીજું કઈ નથી. Detail of the property and everything has to be given by you only na.
એના માટે સર 2140 છે સર
2140 फाइलिंग क्या से चालू થાય છે
2110.
2110 ચાલુ થયું ને 105 goes to if you don't provide me anything then I can dismiss it. Immovable body. 40 proceedings on appearance of judgment debtor. Judgment debtor ની વાત નથી. Attachment of property ની વાત નથી. What you have to give me details શું આપવાના છે?
Sir, property ની details sir અત્યારે અમારે
તમારે જ આપવાની નહીં મને 105 માં કીધું છે. How do I come to know કોને ક્યાં મોકલવાની, કઈ કોર્ટને મોકલવાની, ક્યાં પ્રોપર્ટી છે? How do I send up notice? બજાવવા માટે શું કરવું પડે મારે? આવી કેટલી છે?
sir હું આપને કહું છું. Sir 2114 નીચે sir હું application આપું છું. એમાં sir એ આવી અને on oath એને sir declare કરવાનું છે કે I possess so and so property.
કોને કીધું?
Sir મેન્શન કરેલું છે sir.
ક્યાં બતાવો? 29 40
21 sir.
21 કયો રૂલ?
40.
40 proceedings of appearance of judge debtor in obedience to the notice of or after arrest. અને પહેલા તો તમારે મને આપવાનું ને કે ભાઈ કોણ કોણ શું શું કેટલું શું શું આપવાનું છે. That is given in 105. 105 માં શું કીધેલું છે?
એ સર હાલમાં સર આ તો ઇન્સ્યોરન્સ કંપની છે સર. We are
ઇન્સ્યોરન્સ કંપની હોય તો શું છે?
પ્રાઇવેટ પાર્ટી પણ હોય સર. If we are dealing with the private party also તો પણ સર એવું જરૂરી નથી ને સર કે plaintiff પાસે always
Hearing of application, the court before which an application under the foregoing rules this order is pending may fix a date for hearing of the application. Where on the day fixed or on the other day of the hearing may be adjourned, the application does not appear or where is called for, the court may take an order. This is okay. Where the application appears and the opposite party to whom the notice is, that is okay, fine. And there is a application of citizen order should be dated order 101, 102, 104. Where is the thing? One details કઈ આપવાની છે? One second. I am missing the order.
એ સર 11 છે જો આપ સર જે
One second.
એપ્લિકેશન માં કઈ કઈ વસ્તુઓ
હા.
જી સર 11
11?
2111.
20. One second.
It can be made orally also or in a written form.
Oral application where a decree is for the payment of money. Oral application of the decree holder at the time of passing of the decree or immediate execution thereof by arrest of judgment debtor prior to preparation of warrant if he is within the precincts or of the court. Okay. Written application ma
જી સર એના કન્ટેન્ટ સર આપેલા છે એમાં. It should contain in a tabular form following particulars, namely number of the suit, name of the parties, date of decree, where any appeal has been preferred from the decree, any previous applications has been made, amount of interest, amount of cost, name of the persons against whom execution of the decree is sought, the mode in which the assistance of the court is
required. So what assistance is required? By delivery of any property specified. What do you want? You want through what? What mode are you wanting to? ये क्या है? J. ये क्या लगे? તમે એ જ લખ્યું છે એ જે prayer છે mode in which assistance is required. Where is the which property you want? By the delivery of any property specified specifically decreed. કઈ property decree કરી છે?
Sir, property details obviously sir અત્યારે એની પાસે ના હોય.
ના જોવે ને એટલા માટે કહો they'll have to first get into it કે ભાઈ કેટલી property ક્યાં છે એ કરવી પડે ને પહેલા તો. How will I come to know? How will the court come to know regarding any? By attachment or sale or by sale without attachment of any property. કઈ property? You don't know. By arrest or detention. By arrest or detention when you have to first come to know about the property કે ભાઈ કેટલી છે then only arrest will come. Appointment of receiver, otherwise as the nature of ground has been required, the court to which an application is made in a rule to may require the applicant to produce certified copies of the decree, that is okay. And arrest matter, you have to state grounds. 11A is something different. Paragraph 12 માં આવે છે if you want movable property you have to state that movable નું કેવું પડે. If you want immovable property to be attached, then immovable property details આપવી પડે. જેમ કે અહીંયા છે ને
સર એ 2140 જે સર આપણે મેન્શન કરું
14
40
હા.
સર એ જ છે કે મારી પાસે સર કોઈ ડિટેલ્સ નથી તો એ વિલ અપિયર બિફોર ધ કોર્ટ અને એને સર ડિક્લેર કરવાની છે ઓન ઓથ કે આઈ પોઝેસ ધીસ પ્રોપર્ટીઝ
એ કયા ઓર્ડર નથી આવે
21 રૂલ 40
હા.
40
When a judgment debtor appears before a court in obedience with the notice issued under Rule 37, 37, discretionary power of to permit judgment debtor to show cause against detention in prison, notwithstanding anything under where an application is for execution of a decree for payment of money by arrest and detention is in civil prison. That is not in તમારા આ લાગુ જ નહીં પડે ને 45(1) માં તો હે ને 10(1) will not be applicable to you. It is in case of arrest only. Or is brought before the court after being arrested. That is not in your case. It is separate an application exempt. Pending the conclusion of the trial under subsection 1, the court may in this discretion order the judgment debtor to be detained in custody. That is also not in.
સર 41 sir, sorry my mistake sir 41
Examination of judgment debtor as to where a decree is for a payment of money. The decree holder may apply to this court for an order that the judgment debtor or the judgment debtor in another be orally examined as to whether or any of the debts are owing to the judgment debtor and whether the judgment debtor has any what kind of
sub rule 2 sub rule 2
to where a decree of payment of money has been remain unsatisfied for a period of 30 days. The court may, on an application of the decree holder and without prejudice to its power under sub-rule 1, by order required by the judgment debtor or by the judgment debtor in cooperation and officer thereof be to make an evidence stating the particulars of the assets of the judgment debtor. કોનો officer?
corporation
કયા corporation? Officer thereof કોનો? Judgment debtor is a corporation. The corporation હોય તો બાકી private party હોય તો whenever
તેમાં આગળ લખેલું છે સર
where a judgment debtor for the payment of money has remained
require the
unsatisfied.
judgment debtor or where the judgment debtor is a corporation
Any officer કયો officer? બંનેમાં કીધું છે.
એ corporation હોય તો ઓફિસર ની વાત છે ને
ના ના કોમા આવી ગયો ને or આવી ગયો ને આગળ. Judgment debtor or where the judgment debtor is a corporation. Any officer. બંને માટે any officer. કયો officer છે? જો વાંચો ને પાછું. By order require the judgment debtor or where the debtor is a corporator
એની ઓફિસર તેરો એટલે સર જે કોર્પોરેશન છે એના ઓફિસર ની વાત છે
ના 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 they read it again. કોમા શેના માટે કહે છે? Any officer for whom? Both of them. તમે સમજે? Any officer for whom?
પ્રાઇવેટ પાર્ટી છે તો સર એના ઓફિસર ની વાત જ ક્યાં છે
એ private હોય કોને વાત કરે છે? There has to be some person who has been defined here. Okay, officer thereof. Thereof whom? Thereof can be only for the
એટલે સર
corporation, but there would not be a comma or ના આવત તો પછી સમજ્યા ને? Or is for what? Or you have to read it separately. તો પછી 30 days the court may on an application of the decree holder and without prejudice to its power under sub-rule 1 by order require the judgment debtor number 1 chalo or the judgment debtor is a corporation any officer thereof to make an તો judgment debtor ને affidavit આપવાનું છે stating the particulars of assets of the judgment debtor.
સર તો એનું ઇન્ટરપ્રિટેશન સર એવું થઈ જાય કે ખાલી કોર્પોરેશન ની હવે સર અહીંયા આપણે ખાલી કોર્પોરેશન સાથે ડીલ નથી કરતા જજમેન્ટ ડેટર ઓર વેન અ જજમેન્ટ ડેટર ઇઝ અ કોર્પોરેશન બંને કેસીસમાં સર
In case of
એટલે
disobedience
આગલું જે સર છે ને ઓર ની પહેલાનો જે પાર્ટ છે ઇટ એપ્લાઇઝ ટુ ઇન્ડિવિડ્યુઅલ ઓર વેન ધ જજમેન્ટ ડેટર ઇઝ અ કોર્પોરેશન.
In case of disobedience of any order made in substitute to the court making the order or any proceeding is transferred may direct the person disobeying the order to be detained in civil prison. Again, same thing it is there. Doesn't matter. Place it. Let's see. આવા કેટલા છે? એક આખું ગ્રુપ બનાવો, ચોપડ બનાવો, પછી એક સિંગલ ઓર્ડર થી કાઢી નાખીશ. નંબર પર પાસપોર્ટમાં મૂકી દેવા. How many matters from you are from HDFC, no? How many matters?
Sir, it is allotted in the name of my brother, sir.
અચ્છા, કેટલી મેટર્સ છે એવી?
Total 4 જેટલી
હા નહીં, આમ આવી ટોટલ આખા ડિસ્ટ્રિક્ટમાં કેવી કેટલી હશે આવી?
તો સર મને જેટલું એલોટમેન્ટ થયેલું છે ને મારે તો એટલા પૂરતું જ છે.
ખાલી પૂછું છું.
હા, જી, sir.
Ask your officer that how many applications have you આ kind ની કેટલી
આપણે માનીએ ને કે બીજા પણ સર ઘણા બધા જે advocates છે, બધાની કાઉન્ટ કરીએ તો સર ઘણી બધી વધારે છે.
ના તો હોય જ ને, અહીંયા કઈ ભાઈ પડી રહી છે અને એમને હું થોડો રિસર્ચ કરી લઉં પછી થોડો કરી નાખીએ એટલે અમારી એટલી પેન્ડન્સી તો ઓછી થાય ને. કંપની તો ક્યાં જાય થાય એટલે અમારી એટલી પેન્ડન્સી ઓછી થઈ જાય એટલા માટે. It must be more than એક્ઝિક્યુશન કેટલી છે આપણે જોડાડો છો ડિસ્ટ્રિક્ટમાં. અને આનું જ્યુરિસડિક્શન ક્યાં છે? આ ભાઈ ક્યાંનો છે? આ ભાઈ
અમદાવાદ.
અમદાવાદ.
શ્રી નંબર 22 કરવાની છે પબ્લિકેશનની કેવી મદદ છે.
પબ્લિકેશન આપી દેજો ભાઈ અમને.
પબ્લિકેશન
થઈ ગયું, વિટનેસ આવી ગયા તમારે?
ના એટલે તો આજે હું પબ્લિકેશન કહું તો રજૂ કરી દઉં.
પબ્લિકેશન તો આવી ગયા, બધા સ્ટેટમેન્ટ ને બધા આવી ગયા.
ના બાકી છે.
કરી નાખો ફટાફટ, હું 3 દિવસમાં પૂરું કરી નાખું છું એટલે વધારે નહીં રાખવાનું. આજે તમારે બધું રજૂ કરી દે. બીજામાં બધા આવી ગયા છે ભાઈ?
એકમાં આવી ગયા છે,
પણ
નામ આવી ગયા છે.
આવી ગયા ક્યાં છે?
તમારે બોલાવી
આવી ગયા. આપનું નામ શું છે બેન? એમનું છે હે? એપ્લિકન્ટ નહીં, જેનું સ્ટેટમેન્ટ લાવવાનું છે. શું નામ છે આપનું બેન? આવી ગયું છે એમનું? આવી ગયું. ચલો એમને મેં ઓર્ડર કરી દઉં. પછી બીજા કોણ છે? બધું આવી ગયું છે. સારું, ઓર્ડર કરી દઈશ. સારું બેન, આપ જાઓ. કોનું છે બીજા?
તમારે
શું નામ છે તમારું? કેનું સ્ટેટમેન્ટ છે? એ એપ્લિકન્ટ છે. કોનું સ્ટેટમેન્ટ કોનું છે?
એક રવિભાઈ છે, એક ધનસુખભાઈ છે.
સ્વાતિબેન દેવજીભાઈ.
સ્વાતિબેન બોલી લો.
નાની દીકરી છે, તો બાર.
કઈ વાંધો નહીં, બોલી લો.
રવિ દેવજીભાઈ. મનસુખભાઈ દેવજીભાઈ.
કઈ વાંધો નહીં, એક વાર ખાલી દરવાજા સુધી આવીને બતાવીને જતા મોડો એમ.
અરે યાદી મોઢું બતાવો ને અંદર.
શું નામ છે બેન તમારું?
ભારતીબેન.
સારું જાઓ,
સારું.
આ ઓર્ડર માટે મૂકી દઉં. આપણે સહી થઈ ગયું. સારું. શું બેન? કરવાના નહીં. આ ખબર તો છે આપણને શું એનું view છે.
એટલે મારે ઇન્સ્ટ્રક્શન્સ ડાયરેક્ટ જ ને સાહેબ કે હું વધારે
29 એકની. બ્રેક નીકળી ગઈ છે.
29 છે.